Assalamualaikum warahmatullahi wabarakatuh. My name is metric number 2419938, and I will be the first presenter for our topic, which is the Islamic law and the concept of Ijtihād during the time of companions, especially Khulafā al-Rāshidūn and its relevance in today's world. Sharia, as we know, is not just a legal system in a narrow way, but actually it is like a comprehensive framework that governs all aspects of the Muslim's life, which includes the act of worship, social interactions, family matters, governance, ethics, and so on. The study and application of Islamic law is known as fiqh, which also known in English as Islamic jurisprudence. Fiqh involves interpreting the Quran and Sunnah to address real-life issues, and Islamic scholars use both textual analysis and contextual reasoning, in which textual analysis here refers to the Quran and Sunnah, and contextual reasoning is used to suit the changing circumstances throughout the different eras. And these legal rulings can be both definitive and interpretive. Definitive is qat'i, which means clear and fixed, and interpretive is zanni, which means open to reasoning. So we can see that this balance allow the Islamic law to be both faithful and as the guidance throughout different circumstances. Moving on to the sources of Islamic law, the foundation of Islamic law lies in its sources, in which we have primary sources, which is the Quran and Sunnah, and as well as secondary sources, which could be ijma, qiyas, and so on. And when clear guidance are not available in the text, the Khulafā al-Rāshidūn uses ijtihād or independent reasoning to make decisions. For example, the Caliph Abu Bakr and Caliph Umar ibn al-Khattab made decisions based on maslahah, which is public interest, and necessity that aligns with the maqasid al-Sharia to adjust punishments during hardships. This also shows that Islamic law is not rigid, but instead it is capable of addressing new challenges while also staying grounded in the initial Islamic principles. Moving on to the role of companions, the companions of the Prophet ﷺ played a crucial role in both preserving and also developing the Islamic law. They ensured that it has like an accurate transmission of the Quran and Sunnah, which remain as the core source of Islamic law, but at the same time they also actively interpreted and applied these sources to newer problems and situations, and their legal opinions is known as fatwa al-Sahaba, which is highly respected and sometimes even deemed authoritative. The era of Khulafā al-Rāshidūn is pretty much important because it marks the transition from prophetic guidance to juristic reasoning. So during this time, governance was based on consultation, discussion, which known as shura, and also ijma, collective decision making between the Islamic scholars, or at the time the Khulafā al-Rāshidūn. This period demonstrated that Islamic law could function as both legal and also as a governance system that adapts to societal needs. In conclusion, we can see that the Islamic law is a dynamic and comprehensive system that is based on its core foundational sources, which is the Quran and Sunnah. But also we can see that the efforts of the Khulafā al-Rāshidūn and the companions, it shows that the Sharia itself is not fixed, but instead it evolves through ijtihad and structured reasoning to remain relevant across times.
Hey guys, today we're breaking down two really important concepts in Islamic law, which is ijma and qiyas. Don't let the Arabic terms scare you because they're actually pretty straightforward once you get the idea. So let's start. So, ijma basically means consensus when qualified Islamic scholars all agree on a ruling about something in religion. This happened after the time of Prophet Muhammad sallallahu alaihi wasallam, when scholars in a specific era all come together and land on the same answer for a legal question. And it's always based on Quran and Sunnah. Think of it like a safeguard that protects Islamic law from misinterpretation. Now, there are two types of ijma, which is ijma azari and ijma as-sukuti. What is ijma azari? Ijma azari is when all scholars all agree on the same argument, maybe through speech, through fatwas, through recorded actions, no ambiguity. Everyone is clearly on the same page, and once this consensus is reached, the ruling is totally locked in. And for ijma as-sukuti, this one is more subtle. It's like when scholars issue an opinion, others hear it, and they stay silent about it. That silence, over time, it will turn into an agreement. As long as there's no sign of they are disagree with the ruling. One of the real historical example is after the Prophet passed away, the companions all gathered in a place called Saqifah Bani Sa'idah. Umar ibn al-Khattab, he supported Abu Bakr to be the caliphate, and the committee gradually accepted, and that is considered as one of the earliest ijma in action. Okay, now on to qiyas, which means analogy. It's basically using reason and comparison to apply existing rulings to new situations that the Quran and Sunnah do not directly address. Think of it like this. If the law already has an answer for situation A and the situation B has the same core reasoning, then you can just apply the same ruling. Simple as that. This became super important in the early days of Islam as the new situation kept coming up, then the scholars needed to come up with ways to solve these issues without just going off personal opinion. Quick example. One of the companions, Ibn Abbas, he used qiyas to decide that all types of teeth deserve the same injury compensation by using an analogy with how finger injuries are compensated. See? Same logic applied to a new case. So to wrap it up, ijma is about scholarly consensus and qiyas is about reason analogy. Together, they are the key tools that help Islamic law to stay relevant and protected across time.
Okay, hi everyone. My name is Agnia Tafiatou Soliha with metric number 2518164. In this presentation, I will be explaining the concept of ijtihād during the era of the Khulafā al-Rāshidūn. This period is particularly important in Islamic jurisprudence because it represents the first phase of legal decision making after the passing of our Prophet Muhammad SAW. And during this time, the Muslim community was facing with new political, social, and legal challenges that required thoughtful and responsible legal reasoning. About the definition and conceptual framework of ijtihād, the term ijtihād linguistically comes from the word jahada, which means to strive or exert effort. And from a technical perspective, ijtihād refers to the maximum intellectual effort exerted by a qualified jurist to derive legal rulings when there is no explicit and direct text in the Quran or the Sunnah or Hadith. It is important to emphasize that ijtihad doesn't mean personal opinion without limits. And during the era of the companions, ijtihad was never detached from revelation. Instead, it operated within a structured framework that guided by Quran, Sunnah, consensus, and the consideration of public interest, or in Arabic you could say maslahah. This balance allowed Islam law to remain both faithful to divine guidance and responsive to changing realities. And next, one of the earliest and most critical examples of ijtihad can be found during the Caliphate of Abu Bakr al-Siddiq. After the death of the Prophet Muhammad SAW, several Arab tribes refused to continue paying zakah and etc. They argued that their obligation was tied only to the lifetime of the Prophet. Then Abu Bakr as-Siddiq exercised ijtihad by firmly rejecting this interpretation. He emphasized that zakah is a permanent pillar of Islam and cannot be separated from prayer. This decision was not merely political but a legal judgment aimed at preserving the unity of Islamic law and preventing fragmentation within the Muslim community. And also, next for the second caliphate, which is Umar ibn al-Khattab, Umar bin Khattab. He is widely recognized for his contextual and principle-based use of ijtihad. A well-known example is his decision to suspend the punishment for theft during a severe period of famine. Although the Quran prescribes a fixed punishment for theft, Umar understood that widespread poverty affected individual responsibility. Rather than applying the law mechanically, he prioritized justice and public welfare. This approach reflects an understanding that Islamic law aims to protect human dignity and uphold fairness in society. And the next one is Uthman ibn Affan, the third caliphate. The ijtihad of Uthman ibn Affan is most clearly demonstrated in the standardization of the Quran. As Islam expanded beyond beyond Arab, differences in recitation styles began to create confusion and also tension. To prevent division, Uthman ordered the compilation and distribution of standardized Quran manuscripts. Although this action was not explicitly commanded by revelation, it was based on maslahah ammah, or public interest. This decision aimed to preserve unity and safeguard the primary source of Islamic law. Scholars often describe this as preventive ijtihad, used to avoid greater harm in the future. And the last one is Khulafā Ali ibn Abi Talib. His ijtihad was deeply influenced by ethical and moral reasoning. During times of political tension and internal conflict, he emphasized justice, due process, and sincere intention in legal judgments. Rather than rigid enforcement, Ali sought a solution that would reduce harm and promote reconciliation at his time. And his approach highlights the moral dimension of Islamic law, where legality and ethics generate together. From those ijtihad, the four caliphate ijtihad, we can conclude that the ijtihad practiced by Khulafā al-Rāshidūn demonstrates that Islamic law is flexible yet faithful to its foundations. Their legal reasoning provides an enduring model for contemporary scholars in addressing modern challenges. Okay, maybe that's all from me. I will pass to the next speaker. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Rebecca and my magic number is 2421838, and I will be discussing in this short video my part in the group assignment titled Sources of Islamic Law and the Concept of Ijtihād during the time of the Companions, especially the Khulafā al-Rāshidūn and its relevance today. So my two parts in this assignment were point number 4, the relevance of the companions' ijtihad in today's world, And the fifth point, the conclusion. So to start with the fourth point, relevance of the companions' ijtihad in today's world. We will start by saying that ijtihad as a Islamic law, as a source of Islamic law, is relevant in the contemporary world thanks to the effort that companions made and their very detailed preservation of their own opinions as well as the opinions of the primary sources, which are the Quran and Sunnah. The companions learned how to do ijtihad from the time of the Prophet ﷺ, where he himself taught them that to use their reason in situations where they still didn't have relevant direct rulings from the primary source, in that time the Quran and the Sunnah, which comes from the Quran. So from these examples, from them and their preservation, the scholars of the times that came after learned how to perform ijtihad and their general applications from the examples of the lives of the companions. And so from their lives we can extract 6 main points. The first one are the guidelines, and the guidelines we mean by them as the general frameworks of how to conduct ijtihad in the implicity and the explicitity of the narrations of the time of the companions, specifically in the time of the Khulafā al-Rāshidūn. We can see that based on their context and the circumstances of their ijtihad, we can deduce how to apply ijtihad. Example is how in a situation, like how to apply it, why to apply it, why it is applicable, and when to apply it. It basically means the general points that we need to look for in a situation when we think of applying ijtihad to it. The second point is the flexibility, and you can see this in the actions of the companions when they performed ijtihad with 3 legal maxims. The first one is hardship begets facility, harm must be eliminated, and when it is narrow, it becomes broad. And these 3 maxims, which we can see manifested in the effort of the companions to perform ijtihad, is a form of mercy for us, and a way to facilitate our lives, and a way to continue to stay loyal to the Sharia even when we are no longer in the time it came. Then we have 2 more points, the mechanism and the methodology. The mechanism is basically how to perform ijtihad, in which the scholars analyze the nuances of the circumstances in which the companions performed ijtihad and try to see if they are applicable in the circumstance they have to do, for example. The methodology that goes directly after is the way or the following of the specific hierarchy on how to perform ijtihad, which is basically looking first at the primary sources, and when it is not found in the primary sources, then they use the reason to find a solution that adheres to the Sharia, not immediately go to reason without checking thoroughly first with the primary sources. Then we have focus and relevance and necessity. So firstly, focus is basically the goal that they had when performing ijtihad, and it was not for their personal gain, it was to facilitate to the ummah performing their actions as time passed and changed in adherence with the Sharia. And they did this with full sincerity, and this is seen by what Abdullah ibn Mas'ud said, that if my opinion is correct, it is from Allah; if it is mistaken, it is from myself and Satan. Allah and His Messenger are innocent of it. And finally, relevance and necessity. This shows that ijtihad remains relevant in today's world and will remain relevant as long as time comes with change, and time will always come with change. And as Muslims, we need to strive to adhere to the Sharia, no matter how different our lives were compared to people before, and how different situations will occur. And finally, for the conclusion, Islamic law is basically made up of the primary sources, which are the Quran and the Sunnah, and the secondary sources, which are the Ijtihād and Ijma and Qiyas. And in this paper we focus strongly on Ijtihād, which is also in the use of Qiyas and Ijma, and we can see how it was constituted and how it was performed since the time of the Prophet, specifically in the time of the Khulafā al-Rāshidūn, after the demise of the Prophet, and from that time we can continue to apply it, and especially as time began to change more, as in today's world. From their example, we know how to apply it, and we continue to apply it, and it is a necessity, seeing that we live in a constantly changing world. And a constantly changing world, there will be constantly new situations that will arise, and so we need to find a way to navigate them in the light of the Sharia. And so we continue to use Ijtihād. So that is all for today. Thank you.
I just had to let you know you're